let's go ahead and get started with our review of contract interpretation. And contract interpretation is the study of what agreements mean. We're going to cover these key concepts today in this review. How to establish the meaning of a contract, and what are the sources of the evidence of that meaning? What are the priorities in those sources? Which of those sources will be more or less important to courts? We're going to talk about extrinsic evidence as opposed to the intrinsic evidence within the four corners of the document, which leads us into the parole evidence rule, the test of admissibility of a particular kind of extrinsic evidence, typically preliminary negotiations that have to do with the contract terms. Once we've determined what terms are within the contract, we will also identify implied terms, things that were never expressed but effectively form part of that agreement as well. And once we've established all of the terms, we will then determine whether those are promises or conditions, which leads us into our next lesson on performance, because whether something is a promise or a condition relates to whether performance is due. So let's then get started with a reminder of contracts. And I guess that's what happens when you put emojis on PowerPoint. That is obviously woman with hand down and man with hand up emojis there in PowerPoint. So didn't know that would come up that way. Anyway, we have our two characters, right? We have our offeror and our offeree identified here. And a typical contract is a bargain between the offeror and the offeree in which a promise is exchanged for consideration. And that looks effectively like this, right? Here's our typical bargain image. We have on the one hand the offeror, also known as the promissor, on the other hand the promisee or the offeree. And the question is, what are they promising? What are the terms in this promise? How do we interpret the meaning that they intended when they struck that deal? We look at Restatement Section 200 for our definition of contract interpretation. And the interpretation of a promise or agreement is the ascertainment of its meaning. Okay, that's a not very helpful definition. Sure, the interpretation of a contract is the ascertainment of its meaning. Where does the meaning of contracts come from? We have to dig a little deeper. And we learn that in order to understand the meaning of a contract, we have to get at the intent of the parties. Contracts is fundamentally about understanding what parties intended. This is a story of private ordering, parties voluntarily entering into agreements that they thought would be mutually beneficial. As a result, their intention is the cornerstone of what that agreement means. Restatement 2011 says, where the parties have attached the same meaning to a promise or a term thereof, it's interpreted in accordance with that meaning. So the simplest state of the world is where the parties said the same thing and meant the same thing, and we will hold them to that. But of course, the world is not always so simple. We sometimes might have to do a little more work and get at some of the evidence to determine what the parties actually intended. We have two major sources, or two major categories of that evidence. We have intrinsic evidence. Intrinsic evidence means evidence in the four corners, written in the document or the contract itself, as opposed to everything else, extrinsic evidence, related to a contract, but not contained within the contract itself. And then we can structure this in terms of sort of priorities of interpretation through understanding intrinsic versus extrinsic evidence. So I've identified 7 types of evidence on this chart. These are 7 sources of meaning in contracts, and they generally fall into intrinsic and extrinsic evidence. The first and best evidence of what parties intended is what they actually wrote down. There is no better evidence than what the parties actually wrote in their contracts. Now, as we'll see, courts don't always honor that, but certainly courts that apply an objective theory of contracts highly prioritize what was in the writing. The writing might also make explicit references to other documents, and those are incorporated by reference. And so those explicit references, especially to laws and statutes, are also a type of intrinsic evidence. You can almost think of it as, while they're not themselves within the four corners, they're drawn into the four corners by reference. And then right on the borderline is the concept of the judge's reasonable common sense. The judge will treat the words on the page, will interpret the words on the page through the lens of their understanding and what they think is reasonable, or how they would sensibly understand the words. This is, in a way, intrinsic, because they are looking at the words on the page, but is in a way extrinsic as well, because any judge or evaluator is going to bring their own thoughts and background into an interpretation. But we're going to consider that on the intrinsic side of the line. Moving then to what is extrinsic evidence, our first and best source of extrinsic evidence is course of performance. And that's what the parties did under this transaction. Then we have course of dealing, what the parties did in other transactions, and finally, usage of trade, which is what other parties do in similar transactions. And we're going to talk a little more about how the UCC discreetly prioritizes those. We then come to preliminary negotiations, which is a funny sort of evidence because often preliminary negotiations is used for a certain purpose, to add or change a term, to suggest that the parties meant something they did not write down. And in those cases, we employ the Parole evidence rule. Courts are variable in how they will prioritize preliminary negotiations, whether it's higher or lower priority than course of performance, but we're going to talk about them in this order because this will lead us to a separate discussion of the Parole evidence rule. And again, a reminder that the Parole evidence rule comes up when you have a signed writing and a party is looking to introduce extrinsic evidence, usually preliminary negotiations of a conversation they had about that contract before it was signed. Again, we also can look at this dividing line of intrinsic and extrinsic in terms of how we determine if a contract is ambiguous. If we can read the intrinsic evidence and it is contradictory, it doesn't make sense on its face, we call that a patent ambiguity. A patent ambiguity is when the contract is not clear on its face, where the intrinsic evidence is not clear, as opposed to a latent ambiguity. A latent ambiguity is when the contract is not clear because the parties had some other understanding. It looks clear on its face, but if you actually ask the parties, they seem to have a different meaning applied to it. Whether courts will admit evidence of latent ambiguity also relates to whether they take a subjective or objective approach to contracting. We saw this concept of ambiguity first in our case about chickens, Frugaliment. And this was a good introduction. It actually predated both the restatement that we're using, the second restatement, and the UCC. It was a sale of goods, but it predated the UCC, and that's why it didn't reference it. And so I wouldn't necessarily cite to it for the law. We have better sources of law, but it did paint a picture of how something as common as a contract for the sale of chicken can have an ambiguity in it. So we explored that as a study in ambiguity as these parties tried to determine whether chicken meant broiler chicken or steamer chicken, and that was our first example of contract interpretation. Then we started to talk more about that first category, how to interpret written terms, that best source of evidence, that number one source of intrinsic evidence. Written terms are intrinsic evidence because they are literally within the four corners of the document. And when we read the document and we analyze what it says on its face, we are working as a matter of law. We are making a decision as a matter of law what that means. And so a judge is able to read that contract just as well as anyone else, and this had some applications when we talk about appellate procedure as well as the canons of construction. We also looked at explicit references in Frugaliment, and these are where we have information that is incorporated by reference. In that case, it was a reference to the USDA standards. And whether or not the judge applied reasonable common sense was another issue that came up as the court was trying to determine whether it would make sense to have a contract for chicken where one party would lose money. That just didn't make sense, and so as a matter of reasonable common sense, to require the party to sell the more expensive chicken just didn't make sense from the judge's perspective in Frugaliment. So this again was a type of interpretation using the intrinsic evidence, but again it was getting there in that borderline of whether it was including some extrinsic evidence, some outside facts and understanding as well. Then we looked at course of performance in that case, and course of performance is the sequence of conduct between the parties under that particular agreement. Same parties, same transaction. And that's our best source of meaning, at least extrinsic source of meaning, for what the parties intended from this contract, what they actually said and did once they were under contract in a relationship with each other. Restatement 2024 describes that. The UCC also goes into course of performance and part of the sequence of conduct. Then we looked at course of dealing. Course of dealing relates to the same parties but in a different transaction. And as you can imagine, while the parties may have intended the same thing for this transaction, it also is quite possible, maybe even likely, that they have a new contract because they intended different terms. So course of dealing, where we have the same parties but a different contract, is not quite as good evidence as course of performance for the party's intention in the contract at issue. The UCC talks about that in 1303B. And finally, we get to then usage of trade, which also comes up in the restatement and the UCC. Again, what does that mean? The usage of trade is different parties in a different transaction. What is generally recognized in that industry as the meaning of these particular terms. And so this can be very good evidence, especially if no other evidence is available. In fact, parties are presumed to have some understanding of the usage of trade. The UCC gets into this in 1303C. And as I was mentioning a moment ago, if it's part of the usage of trade, parties who are in that trade are presumed to have knowledge of that usage and are presumed to be using a term with that intention. And so, interestingly, usage of trade, although the lowest in our sort of order of extrinsic evidence, also has some impact on the intrinsic evidence. And it falls into, it's canon number 2, right? And so the way that we would use usage of trade is variable, depending on if the parties are in that trade and whether we would expect them to have applied that meaning. And finally, preliminary negotiations are this issue that relates directly to parole evidence. And we'll talk about that in a moment. The parole evidence rule, just for keeping track, is in 213.2 and 213 of the restatement. We'll come back to that. So on the parole evidence rule, I did mention that we will focus specifically on, at least on this exam, of how the parole evidence rule is applied in Pennsylvania. And while you didn't have to read these full cases, I want to take a moment and remind you that Pennsylvania has said some pretty clear things about how to use merger clauses in cases of trying to admit parole evidence or extrinsic evidence. The court says that if the written contract appears to be complete, then we're going to assume that the court takes the objective theory of contracts, and it's going to believe what the contract says. And the presence of an integration clause is viewed as a clear and persuasive sign that the writing contains the entire agreement. So we have to identify the merger clause, but once we have, we will rarely take a subjective view and ask for extrinsic evidence to determine if the parties really meant it. So those are our overall types of evidence that we will see when we are analyzing a contract. We will look at written terms first and foremost, which may incorporate by reference other documents, and applying common sense to those terms is theoretically an exercise in law, but really brings some of that extrinsic evidence of a person's knowledge and background information. And then we would look at course of performance, course of dealing, and usage of trade, and whether or not preliminary negotiations can come in is subject to the parole evidence rule. By the way, in Nanakuli, we saw that courts don't always follow this order very strictly. In fact, in Nanakuli, the question of whether or not price protection would come into the contract elevated usage of trade to such an extent that it ignored the clear written terms. Nanakuli was an example of the subjective approach in contract theory, and it once again showed that where the court felt strongly the parties did not intend what was written down, it overruled the writing by listening to the parties. And that made it a bit of an unusual case, but it's certainly not unheard of in contract law for courts to take that approach. The UCC requires us to look at course of performance, course of dealing, and usage of trade in that order. And in fact, as a result, the UCC also always requires courts that are dealing with sales of goods are things that are movable and identifiable at time of sale, to take into account these elements of extrinsic evidence. In a way, the UCC is requiring a somewhat subjective view of contract theory by requiring courts to consider these elements. Nanakuli, however, I think did not follow the UCC strictly. It flipped, in a way, usage of trade and prioritized it very highly, although course of performance was also at issue in that case. Let's then talk about the canons of construction. We're going to focus now on that first element of reading the contract. What do the written terms mean? The canons of construction are used to interpret written terms, and so they are used as a matter of law to determine what a contract means based on intrinsic evidence within the four corners. In this class, I specified 13 plus 1 canons, but I don't want you to come away thinking that this is an exhaustive list. The UCC brings up, the restatement brings up fewer than this number of canons. Other sources will talk about 40 or 50 or 60 canons of construction. But these are some helpful guidelines for us to follow. And as I mentioned, at least for the purpose of this class, you can treat them like rules. They are rules of construction, and I've numbered them in this way for your convenience. But I don't want you to think that this is like black letter law. But for our purposes, we're going to apply these canons, and we can use these numbers to identify them. The most problematic one is construction against the drafter, or contra preferendum. It's like waving a magic wand and declaring, you win, even though we can't understand the contract. And so courts will only use contra preferendum as a last resort when the other canons fail. And they will do so only when there is some asymmetry in bargaining power that justifies construction against the drafter. We saw that happen in Clapp. In Clapp versus UIG, we had effectively one agreement made out of two different writings. The writings did not agree. One had a particular length of time that was required before receiving severance. The other had a different length of time. There was no way to square them. The operation of the canons did not resolve the issue. And so as a result, in this case, we waved our magic wand construed against the drafter. So UIG is the case that stood for that. Now that we've covered intrinsic evidence, let's talk about admitting extrinsic evidence and using that to understand contract terms. So now we're below the line here, and we're going to build from course of performance, course of dealing, and usage of trade to get to the Parole evidence rule. Whether or not courts are going to admit extrinsic evidence depends first and foremost on whether the intrinsic evidence is clear. If the intrinsic evidence is not clear, if the intrinsic evidence is patently ambiguous, if you cannot understand the contract based on its written terms, courts will always admit extrinsic evidence to determine the meaning the parties intended. Things get a little trickier, however, when the contract seems clear on its face. Will courts admit extrinsic evidence to show a latent ambiguity, or to show that the contract meant something other than what it clearly says? Well, that depends on whether courts are taking an objective or a subjective approach to contracts. Courts that take a more objective approach will strongly prefer the writing and will be very, very hesitant to admit any type of extrinsic evidence where the writing is clear. Pennsylvania seems to be following the objective approach. In other courts, we saw this in several cases, courts will be more likely to admit subjective evidence because they really care about getting the intention of the parties right. And that, again, deals with our kinds of ambiguity that we spoke about. We saw this in two separate cases. In C&A construction, we had an objective theory of contract interpretation, and we then put that, juxtaposed it with PG&E, where we saw the subjective theory of contract interpretation. So those two cases came out differently because the judge thought about the rules of law differently. In C&A, we have the objective theory, which is that if a written instrument is clear and unambiguous, the court's duty is to construe the document according to that plain meaning. In PG&E, we saw the subjective theory, which said that even if the agreement seems unambiguous, language is inherently ambiguous, and we can look for a latent ambiguity. We can admit extrinsic evidence to prove that the contract does not actually mean what it seems to. Course of performance, course of dealing, and usage of trade are always admissible under the UCC. So in that way, the UCC is requiring some amount of what you might consider a subjective approach, something similar to the subjective approach for contracts under the UCC. Which leads us then to the Parole evidence rule, a particularly tricky rule, which we broke apart into two steps. Remembering that Parole evidence deals with extrinsic evidence and usually, almost always, deals with extrinsic evidence of preliminary negotiations because it has to deal with evidence about the contract that occurred before the contract was signed. Just a quick reminder, there's no E. The Parole evidence rule does two things. It bars evidence of prior negotiations that alter final written terms. And it bars evidence of prior negotiations that adds terms to a fully integrated agreement. Now that's easy to say, but it's a little harder to break that down and make meaning. What does it mean to have a final agreement or a complete agreement? So we're going to do this in a two-step process, and you might even break step one into two sub-steps. The first step is determining the nature of the contract. Is the contract unintegrated or integrated? And if it's integrated, is it fully integrated or is it only partially integrated? And so that's step one, or you can think of it as step 1A and step 1B. Once we've understood the nature of the contract, we can then ask, what's the nature of the evidence? Because depending on the nature of the evidence, we may or may not admit it. And so how do we determine the nature of the contract? Well, the best evidence of the nature of the contract is, again, in the writing. And the writing may tell you that it is integrated. That's called a merger clause. It's also called an integration clause. A merger clause is intrinsic evidence because it's actually written in the contract. And again, in Pennsylvania, courts generally find a clear and unequivocal merger clause to be presumptive, and that they will not look for subjective evidence in the presence of a clear and unequivocal merger clause. Of course, there can also be extrinsic evidence that the contract was complete or not. Courts that are more leaning toward the subjective theory will look at the extrinsic evidence as well. So we saw two different approaches to this as well. Very much like C&A and PG&E, we saw a series or a sequence of cases, one in which we took the objective theory and applied it to a merger clause, and another case where we took the subjective theory and applied it to a merger clause. And as a result, we got different results. In one case, the merger clause was held to be binding. In the other case, the merger clause was not. Pennsylvania generally finds that merger clauses are presumptive. In other words, it takes the C&A, or the objective approach. If the contract doesn't have a merger clause, then that's like the contract being ambiguous. When the contract is ambiguous with regards to any term, the court will look at extrinsic evidence. Much the same here. If the merger clause is ambiguous or missing, the court will look for extrinsic evidence to determine if the contract is final, and this or complete for that matter. And we saw this play out in Middleton Concrete Products, where although the contract had a merger clause, there were three of them, and the court did not believe that all three could be complete and exclusive, so it looked at other evidence to determine whether or not this was in fact a complete and total integration. Middletown also reviewed a couple factors that you can look at. So if the merger clause is not persuasive, if it's either missing or ambiguous, Middleton stood for or brought to us several factors that can be used to determine whether extrinsic evidence shows the contract is fully or completely integrated. I also broke this down in a flowchart, and I hope this is helpful, but this took the kind of 1A, 1B approach. Again, the first step is determining the nature of the contract. And we can determine that based on the evidence on its face, the intrinsic evidence. And as you can see in this chart, if the intrinsic evidence is clear and unequivocal, and the court does not take a subjective approach, we will find that it is binding. If that merger clause is missing or ambiguous, we'll look at extrinsic evidence and most likely find the contract is not complete without a merger clause, but it might very well be final. For example, if it is signed or says final on it, or we have evidence the parties met on a particular date to have a signing. And by breaking it up into two steps, we simplify the process, I think, a little bit by first simply determining if the contract is final or not, and then if it is final, is it also complete? And so we can take a two-step approach to this, if that is simpler for you. Once we've understood that nature of the contract, we look at the nature of the evidence. If the evidence is to show defective formation, the parole evidence rule does not knock it out. If the evidence is used to explain a term, as opposed to modify or add a term, the parole evidence rule does not knock it out. Although courts that take a more objective theory may not admit evidence that is meant to explain or change the meaning of a clear term. So that's a question of whether or not the court will take more of an objective or a subjective approach. And as a kind of side note there, you can always admit extrinsic evidence of course of performance, course of dealing, and usage of trade if the contract is governed by the UCC to explain a term. Evidence of subsequent modification is also not blocked by the parole evidence rule because parties are always free to modify their agreements. And collateral contracts, which we defined in Seagram's, are also not going to be knocked out because by definition they are not expected to be part of that particular contract. And so that leads us then, once we have determined on the left here the nature of the contract, and on the top there the nature of the evidence, we can use this to determine whether that evidence will be admitted or barred by the parole evidence rule. So again, we have 7 different sources of meaning, and I'd like you to use these specific terms when discussing the evidence that you're talking about in your essays, just so we have a common language. Written terms, explicit references to outside sources, the reasonable common sense a judge or person might apply in reading a contract, course of performance, course of dealing, uses of trade, and preliminary negotiations are 7 sources of evidence, and really most of where you would get evidence of what a contract means. However, even though the parties did not expressly say or do something, they still might have intended the contract to have a meaning. And this is the doctrine of implied terms. Terms can be implied as a matter of fact, as a matter of law, or by the doctrine of good faith. And by the way, law, of course, involves the common law as well as statutory law, and so there are certain gap filler provisions under the UCC. So you can think of it as 3 or 4 sources, depending on whether you want to break law into common law and statutory law. Let's first look at terms implied in fact. Terms implied in fact means the parties actually wanted these terms to be in the contract. They just didn't write them down for one reason or another. And the fact finder's job is to determine the intent of these parties and to feel confident that both parties had a shared meaning and desire for these terms to come in. This was the case in Fisher. This was a case about a rabbi who was an Orthodox rabbi who made a contract with this synagogue, which was an Orthodox synagogue. The synagogue later changed one of its policies that did not conform with traditional Orthodox rules. And the question was the confirmation with Orthodox law part of that contract? Even though the parties did not discuss it, it was implied in fact. Both the congregation and the rabbi, when they made the contract, would have intended that the service that he was to perform be in compliance with how they mutually understood Orthodox law. And so we took a testimony of the rabbi, we looked at other evidence to see what these parties actually thought. And that's a term implied in fact. A term might also be implied in law. And we saw this in the case of First National Bank of Lawrence v. Methodist Home for the Aged. In this case, one of the parties died. When a party is dead, you can no longer put them on the witness stand and get testimony. And as a result, the court can only interpret what the contract meant as a matter of law. You can't actually arrive, or at least maybe you could. In this particular case, there is not sufficient evidence of what the parties themselves would have intended. So the court then instead focuses on, in this case, common law. And it looks at how other courts resolve the same issue of whether money had to be refunded if a person died during a probationary period. In addition, the UCC has gap filler provisions. And these are terms implied in statute. And so if a contract is for sale of goods, it will have a number of terms that are implied as a matter of law. And in ways, these are clearer than terms implied in common law because they're actually and expressly written down in the UCC and identified as such. And these are an example of some of the key provisions. And then we discuss terms that are implied in good faith. Every contract has a duty of good faith and fair dealing implied in it. In fact, we could even say that every term has a duty of good faith and fair dealing implied in it. The restatement makes this point in Section 205. The UCC accords in Section 1304. But what does good faith mean? It's very hard to define good faith. The UCC attempts to define it in 1201 as honesty in fact and observance of reasonably commercial standards of fair dealing. But the restatement does not define good faith. It's a very open-ended concept, maybe deliberately. It provides flexibility in the law to determine what a reasonable person would have intended for a given contract. We saw this in Wood v. Lucy, Lady Duff Gordon, where we had a term implied in good faith. The contract was about putting a stamp of approval on certain fashionable prints, and they were to share the profit, split them half-half. Did one person have an obligation to produce any prints at all? Well, under the contract, as a literal matter, no. It didn't say we have to produce X number of garments or you're going to get paid per garment. But there is a duty of good faith to bring the fruits of the contract into existence. And so that was our first case in that sequence. We saw a much more detailed and more current case, Market Street Associates, where we had a term implied in good faith in that contract as well. Once we've determined what all the terms in a contract are, both express and implied, what the contract means and the intent of the parties to include things they did not actually say, we can then determine if those things are promises, independent promises that will be obligatory regardless of anything else, or whether they are conditions which will cause a promise to become due or not. An express condition will be something written or stated, and an express condition is going to cause the other party's duty to perform to come due or to be extinguished. The restatement defines it in 224. A condition is an event not certain to occur, which must occur, unless its non-performance is excused, before performance under a contract becomes due. Note that we're already talking about performance, and so this is a concept that goes very neatly into our next conversation about contract performance, whether contracts were performed or whether they were breached. And again, a little handy-dandy chart. We add one complicating factor to our chart regarding, our image regarding the deal, and now we see that there is a condition operating on that promise. If the condition does not occur, that promise is not yet due. But there is still a contract. The existence of a promise, a condition, generally does not make the contract illusory. Section 225 discusses that first effect, that until the condition comes due, the duty subject to the condition does not have to be performed. That's 225.1. And we saw this come about in Morrison v. Baer, which actually stood for a number of concepts. But here, there was a cracked heat exchanger in a home. And there's a contract to buy the home. And there's a special condition that said, I, the buyer, do not have to buy the home unless the heat exchanger is fixed. And it taught us two things. One, it taught us that when that heat exchanger was not fixed, the other person did not have to buy the home, but could not force the home to be sold at a lower price. And relatedly, failure to bring that condition into existence was not a breach by the other party. Restatement 225.2 goes on to the second effect of a condition. At some point, the condition can never occur. If the condition can never occur, either because a reasonable time has elapsed or because it's no longer possible for that condition to occur, we say that the duty is discharged, which means that performance will never become due. In the first instance, it was a temporary period. We're sort of an appendency where the duty could become due. However, that duty can be discharged and never due. And then, again, reiterating the point that in 225.3, non-occurrence of a condition is generally not a breach unless the parties intended otherwise. We did see a case where parties intended otherwise. That was International Rotterdam. When a party has a duty to perform a condition, it is called something different. It is called a promissory condition, and that's what that was the case of shipping the rice. Here, a party had an obligation to provide a location. It was location A or location B. You can't ship rice if you don't know where you're shipping it to. The party had an obligation to state that location. In Peacock, we also saw another way courts deal with conditions. There's a problem with conditions. They have to be complied with strictly. Here we had the contract, well, let's say the contract was ambiguous, but one reading of the contract was that the subcontractor would not get paid until the general contractor got paid. Another reading was that this just provided a set of mutual promises that I will pay you, and here is some general concept of when you will expect to get paid. But it did not create a condition. The court, in this case, read that provision as a promise and not a condition to avoid a harsh result. We have a particular issue with conditions of satisfaction. A condition of satisfaction means that your duty to perform does not come due if you are not satisfied. And usually this has to do with someone's obligation to pay. I don't have to pay for the aluminum siding if I'm not satisfied with the job. Well, what does satisfaction mean? There are two kinds of satisfaction, objective and subjective. And subjective satisfaction is sometimes called honesty in fact, right? Going back to the idea, was the person actually satisfied? Were they honestly unsatisfied? Now, very easily we could see how if a person could claim for any reason or no reason that they were not satisfied and therefore did not have to pay, this could make a contract illusory because the party could then avoid any liability. But the duty of good faith and fair dealing precludes that. So we have honest satisfaction, satisfaction in fact, which is subjective, and then we have the concept of objective satisfaction, reasonable satisfaction, which relates to whether a person in that position would reasonably be satisfied. both again subject to the duty of good faith and fair dealing. The restatement in 228 makes it clear that objective or reasonable satisfaction is preferred. When at all possible, we will take an objective approach to satisfaction because it's so hard to determine if a person was satisfied in fact. We saw this in two cases. We saw in Hutton v. Monogram Plus whether a party was satisfied with terms of a financing on a monogram machine. It was a commercial matter. Whether they were satisfied or not was an objective standard based on what was commercially reasonable. We saw the same in Moore and Building. And in Moore and Building, it was even more compelling because that contract actually said artistic satisfaction. But the court did not give them that standard because it was an aluminum siding on a building. And so we then learned that when are we going to apply an objective standard, when a subjective standard? Well, we see that the courts strongly prefer the objective standard, going so far in Moore and Building as to overriding the writing to get to that result. But we do have some clear standards. We apply the objective standard generally when we have something commercial. It's the preferred method. We'll apply we apply the objective standard when we have something commercial and we can arrive at that practically. But we apply something subjective generally only in matters of art, music, where we're really talking about someone's personal taste. And the person on the other side would reasonably know that they were subjecting themselves to their whim or fancy. What's the result? Well, in the objective standard, we actually ask, would a reasonable person in the position of the obligor be satisfied? We don't actually care that this obligor was satisfied or not. In a subjective approach, we actually have to determine if that particular obligor was in fact satisfied. That's why it's called honesty in fact. One is a matter of law, one is a matter of fact. Now, since conditions can have this harsh result, sometimes courts will excuse them or find that they were waived, and parties can also waive them voluntarily. The restatement doesn't talk much about waiver. That's more of a doctrine. If you want to look it up in the restatement, it's section 84, and it has to do with contracts without consideration, because waiving a condition is effectively making a new contract with no new consideration. You can do that if you follow the special rules. Courts can also excuse a condition, and we look at section 229 for that. We saw both occur in Burger King. In Burger King, there was both waiver and excuse. We saw an implied waiver because parties had a course of performance where they permitted unscheduled or beyond scheduled construction to take place. And the court also said that it would excuse the condition because it would create an unjust result. In J&A Realty, we had the excuse of a condition framed, again, as the concept of implied waiver. And here, the court again found that it would be unjust or unfair for a party to be held to a condition to provide notification on time. I do invite you to consider the vigorous dissent in this case, which made the point that why should we give this particular party a free lunch, so to speak, when that's not what the parties intended. So the key concepts for this chapter are we're trying to determine the meaning of the contract. And to the extent that we can, we want to honor the intention of the parties. We do that by first reading the contract. Our best source of meaning is our intrinsic evidence, endemic to the contract, within its four corners. But sometimes those four corners are ambiguous or not clear. And under the UCC, we always admit extrinsic evidence of course of performance, course of dealing, and uses of trade. And sometimes subjective courts will allow that evidence, or maybe even evidence of preliminary negotiations, to show that the parties had a latent ambiguity in their writing. They intended something different than what they wrote. This gives us a general set of priorities of construction, so we know how to follow that order. And whether or not we're going to admit extrinsic evidence deals with whether the contract is ambiguous and whether the courts take an objective or a subjective approach to that type of evidence. We then introduced the Parole evidence rule, which was specific to contracts that are written where parties are seeking to introduce evidence that occurred before and related to the contract. Generally, that would be evidence of preliminary negotiations that for whatever reason were not embodied in the writing. Terms that are implied can also come into the contract if the court finds, in fact, the parties had intended the same meaning, or if it determines in law the parties should have intended a meaning, or if a statute on point says that there are certain terms that are going to be implied in law. And the duty of good faith and fair dealing is implied in all contract terms, which particularly applies to conditions of subjectivity, where the duty of good faith prevents contracts from being illusory. And in fact, conditions in general are subject to various equitable remedies because they do create such problems, because they have to be completely and totally performed, otherwise performance is not due. And we'll see when we get into our next chapter on performance that implied conditions have a bit of a softer rule, and we'll talk about the doctrine of substantial performance with regard to implied conditions. But we're not quite there yet. We're getting there. But that's it for Chapter 8.